The job of the president. There are a lot of ideas about what the president should do and be, but today we're going to look at the Constitution and look at the oath that the president swears in order to become president, and without which no one can be president unless you say these particular words that are written down in the Constitution. Then looking at an example in James Madison of what he viewed the job of the presidency to be, how that worked out practically, his veto message. He actually vetoed a bill that he agreed with. Now, why would a president do such a thing? Why would you veto, reject, send back with objections legislation that you agreed with? And as Madison will articulate, it's because he believed he had a certain role as president that superseded his own personal desires and political agenda. And I believe that was tied to his oath. The Constitution says in Article 2, toward the end, it's not a very long section. The section dealing with the presidency is about a page, about a page and a half. There's a second page. But not too much is said there about the presidency, but it does say this: before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of the President of the United States, and will to the best of my ability preserve, protect, and defend the Constitution of the United States. So the job of the president is execution of the law, executing the office of the presidency, and to the best of ability, preserve, protect, defend the Constitution of the United States. Now, an irony that I've brought up many times, and if I think too much about it, actually is fairly offensive to me if I get into it, is that presidents, in order to become president, must swear these words. They must say these exact words. The Obama oath, some words were jumbled just by mistake between the Chief Justice and President Obama as they were saying these words. And out of an abundance of caution, which they always say, Obama re-swore the oath. Because technically, according to the Constitution, you cannot become president unless you say, you're elected and all that, but then you have to say these words. And it's at that point, that swearing in, that the president officially takes on that role as president. But my point of contention, my issue that bothers me is that there's been this focal point for presidents for over 200 years, going back to George Washington, that is legally documented in the Constitution, that they swear to uphold, preserve, protect, defend the Constitution of the United States to the best of their ability. That being said, it seems that there is more of a focus on the saying of particular words while also disavowing the oath. And this is all modern presidents, and we could say this is all presidents in general. Although I think in James Madison, for his flaws, we do see a way where this is worked out consistently, where since the president swears an oath, and the president is not the only one who swears an oath to uphold the Constitution, so do all the members of Congress, so do the members of the Supreme Court. But if the Constitution is meaningless or simply irrelevant and may be ignored, then the oath is meaningless. In my opinion, breaking the oath should be an impeachable offense and removal. Impeachment is the beginning of a process toward removal. However, no president has ever been removed, and let alone removed for failure to uphold this oath. Now, this comes to a view of the presidency, which is that the presidency, along with the other branches, is an independently constitutional branch. Others may take other views on this, but it seems in swearing an oath to uphold the Constitution, those in Congress who swear that oath, their judgment ought to be first and primarily, is this bill, do I believe this bill before me that is being crafted is constitutional or not? I have sworn an oath to uphold the US Constitution. Does it break the Constitution, or is it simply non-constitutional? And if their answer is no, then according to their oath, they should be duty bound to vote against it or at least abstain. Then they'd ask, is this a good idea for the people that I represent? And those are maybe equally important. But if either answer to those two questions is no, then they should vote against the bill. But there are differences of interpretation, fine. But after bills are created and go through that process, they eventually, if they get that far, get to the president's desk for final signature before they become a law. The president has the option to sign it or to veto it. An independently constitutional presidency would see as that individual's duty, having sworn the oath, to not only decide whether that individual agrees with it or not, that is part of it, but primarily see whether or not it's constitutional. And if the president believes that a piece of legislation before him is unconstitutional, according to his oath, he must reject it. And I believe the same thing goes from the Supreme Court, that they're supposed to be independently constitutional branches bringing accountability. Now, this is not that the Constitution is an unqualified good, or that the Constitution can't be changed, or that the Constitution is always right, or doesn't have mistakes, or problems, or foresee things. As we're going to see, James Madison thinks that the Constitution at this point is perhaps lacking something important that it maybe should have. But it is not for political elites to decide where legal limitations apply and where they do not. Furthermore, it is not for political elites, especially elected ones, or even unelected, like the Supreme Court, other federal courts. It is not for them to decide the parameters of how something should be changed, like the Constitution, when they swore to uphold it. It is not for them to exercise political power in any particular direction they think is fitting. Because if that is the case, then that leaves open the option for political elites, whether you like them or not, to make decisions not based on anything other than their own self-imposed authority. And then it's an unlimited government. So it is not for political elites to decide their own limitations and decide to change the very thing they swore to uphold by interpreting it into meaninglessness. Now, the Constitution can be changed, and maybe many, and it has been, and may argue maybe it ought to be. There are lots of areas where The Constitution may not be sufficient to handle some issue, or it could be reworked, or whatever the case may be. However, there is an amendment process to the Constitution. The Constitution has a built-in way of changing, that there are legal parameters. And the point of this was to specifically prevent people in political power from exercising that power in a way that was illegal. That's why we have a written constitution. Problems notwithstanding in the Constitution. And so, James Madison, when he was president, received a certain bill. And I'm going to go through this, his veto message. So he included a message explaining why he was not going to sign a particular bill with which he agreed. Now, it would be one thing if he said, I don't like this bill and it's unconstitutional. But he said, actually, I like this bill, but I believe it's unconstitutional. What choice should be made in that case? James Madison believed that it should be rejected on the basis of being, in his opinion, unconstitutional, and that it was his job as president to participate in that aspect of being an independent constitutional branch of the federal government, that each branch looks at the Constitution and interprets it, along with the states as well, leading to whatever problems that leads. That was his view. And so this is a bill about internal improvements. Internal improvements means government money that has been taxed in order to pay for things like roads, bridges, the widening of canals, things of that nature. Seems pretty innocuous, right? In most cases, this is one of the things, the most basic things people think of when they think of government. I'm not saying that's correct necessarily, but most of the time is people associate government with these sort of infrastructure items. And so there's a request, an act set apart to pledge certain funds for internal improvements. Roads, bridges, canals. And so Congress makes this law. And now their argument is we can do this because the Constitution states in the powers that are listed in Article 1, Section 8 of the Constitution, which talks about the areas in which Congress can make law, and that law in those cases supersedes the law of the states that have joined the Union. It argues in certain places that this is according to the general welfare of the United States. It's, quote, the general welfare is in the Constitution, or it is necessary and proper to carrying out the actual execution of the laws made by Congress, or some other the supremacy clause that the Constitution is the supreme law of the land, and therefore that's often interpreted that Congress has a supremacy over any law of the United of any of the particular states. But James Madison, who's sometimes called the father of the Constitution, did not believe that when he was in the position of president. So he gets this bill, and he thinks that these things to be done by the bill are a good idea. But he vetoes it, and he says why. He says the legislative powers in Congress are specified and enumerated. Specified means that they have been laid out specifically, not generally. Meaning Congress doesn't have an ambiguous general power to do whatever it wants. It's been limited to what has been written down in the Constitution. Enumerated means that there has been a numbered list spelled out of what Congress is allowed to do. Everything else, as it's spelled out in the 10th Amendment, that is not spelled out in that list remains with the states or with the people. So that is a very limiting perspective on the Constitution. And many people don't like that. There are different views on those things. That being said, this was James Madison's view that the powers were specified, not general, and enumerated, not infinite. There was a list of what government was allowed to do, areas in which Congress was allowed to make law. It's in the eighth section of the first article of the Constitution. And he goes on to explain his rationale, and he says, it does not appear that the power proposed to be exercised by the bill is among the enumerated powers. So James Madison articulates his rationale. He says, look, so Article 1, Section 8, there's a list of powers. Now, they may not be the right powers, they may not be enough, and they may need changes. There's an amendment process for all that. But all those in the federal government have sworn an oath to uphold the Constitution, whatever the Constitution's flaws may be. The Constitution gives Congress a list of powers and a list of areas over which they are allowed to make laws. These are powers that this particular states originally had given up in order to join in a union. And so James Madison argues, he says, it does not appear that the power proposed, the bill that is in question about raising money for canals, roads, bridges, infrastructure, internal improvements, he says the problem with it is not that it's not a good idea, but the ability for Congress to raise money for such a purpose is not contained in here. Now, wait, some may say, but it talks about the general welfare. It talks about making post roads. That's something. It talks about raising taxes for the general welfare of the United States, the necessary and proper clause, that the government can do what is necessary and proper in the pursuance of fulfilling the Constitution. It has the supremacy clause, that the US Constitution is supreme in those areas in which are spelled out in the Constitution. All that's true. But Madison says, no, that isn't what those clauses mean. Because he says, if that were the case, then you could pretty much interpret anything, and a written constitution would become void. It would become an unwritten constitution, which is what the Americans rejected by writing the Constitution down. Not a lot of people know the British had and have an unwritten constitution. The Americans wrote theirs down on purpose, good or bad, in order to limit the range of interpretation for government power. So James Madison's contention is that, in his opinion, he could have been wrong, but in his opinion, he says it does not appear that the power proposed to be exercised by the bill is among the enumerated powers. Now he says, look, some argue that this is to provide for the common defense and the general welfare. And he says that this would be, I'm going to highlight this here as well. He says the problem with this is this would be contrary to the established and consistent rules of interpretation. And what he's saying is this: if you're told you're allowed to do 3 things, but you're also allowed to do whatever you want, there becomes a contradiction between those things. In the sense that, yeah, within whatever you want can include those 3 things, but those 3 things limit and exclude other things. And so he says, look, if we use the idea of general welfare means that the government, anytime it makes a case that what they're doing is for the good of the people, the general good of the whole United States, then really anything at all could be done by government under that um, justification. So he says, to do this, he says, rendering the special and careful enumeration of powers which follow the clause nugatory and improper. Now, that may not seem to make sense at first, but he says, look, if we say general the Constitution does say, it's right here, Article 1, Section 8, Congress shall have the power to lay and collect taxes, duties, imposts, excises, for what purpose? To pay the debts of the United States, to provide for the common defense, and the general welfare of the United States. And then it goes on and lists other powers. Now, James Madison says, now it does say general welfare. Okay, so if general welfare doesn't mean that Congress can just raise money, according to Madison, can raise tax money for whatever it wants, then what does it mean? Well, James Madison explains, he goes, well, look, yeah, we get that not everything is going to be put here. But he says the problem with the interpretation that Congress can raise money for whatever is the fact that following the statement about general welfare, there's a list of powers. So James Madison's argument, I believe, would be, what is the general welfare of the United States? How do we define that? It's within these powers or whatever may be amended to the Constitution. It's not open to the interpretation of politicians deciding how much they think they should be able to exercise their power. It's according to what is listed as powers that were agreed upon in the Constitution. So he says, look, if you just say general welfare says whatever you want, he says that makes a list pointless. Why give someone a list if they're allowed to do whatever they want? He says that would give the following clause nugatory, meaning it would basically cross out and make it meaningless, and improper. He says such a view of the Constitution would have the effect of giving Congress a general power of legislation instead of a defined and limited one. So Madison didn't believe that. He didn't believe that Congress could just make laws over whatever areas they decided was right, and the Americans just had to go along with it because, well, Congress is supreme. They said it's in our general welfare, and it must be. No, he said the point of the Constitution was that a Constitution was not to give Congress a general power, but a specific one, a defined and limited one, hitherto understood to belong to them. Says it would have the effect of subjecting both the Constitution and the laws of the several states in all cases not specifically exempted to be superseded by the laws of Congress. That's very important what James Madison is saying there. He goes, if that was the view, and this is actually the view that most Americans, I believe, hold today, that they see it like this: Congress makes a law, your state makes a law, your city makes a law. Since Congress is at the top in their mind of authority, that Congress's laws automatically supersede that of the states or cities or whatever more local governments. That wasn't necessarily James Madison's view. He says it would have the effect of subjecting both the Constitution and the laws of the several states, not specifically exempted, to be superseded by the laws of Congress. And that was not the point of the constitutional union. They didn't create a constitution and states joining in a union together as equals. They didn't then say, okay, well, now we hand over all power without question to whatever Congress decides, and its laws win exclusively no matter what. Why would the states have participated in that? He also argues, now Madison may not be right in his argumentation, but he says his view is that if you just give Congress a general power of legislation to make laws over whatever it wants, then he says basically that undermines the Constitution and all the laws of all the states. Because Congress is the true authority at that point, not the Constitution or the states. He also says it excludes judicial authority from participating in this, that, well, obviously the judiciary is supposed to be there as a limiting factor as well to help navigate between national law and the Constitution, or treaties and national law, or treaties and the Constitution, or anything, those things that may be there that may contradict it. The Supreme Court is supposed to render an opinion on how to navigate that type of situation and to talk about their view of how to understand the Constitution in those cases. And Madison believed if the national law was made contrary to the Constitution, it was void. So he also says the assent of the states in the mode provided in the bill cannot confer the power. So he said, look, if there's a general power to construct roads, do all this stuff that is being claimed by the bill to make these internal improvements, he says that power really isn't possessed by Congress. He says, but it could be done through the assent of the states in the mode provided, but the bill could not confer that power. It could also be done through a constitutional amendment to change the Constitution so that now it is allowed. It says the only cases in which the consent and cession of particular states can extend the power of Congress are those specified and provided for in the Constitution. So he says here, that his point is the only areas where states have given up their sovereignty in decision-making and lawmaking and governmental power are those areas that are specifically listed in the Constitution. Otherwise, by implicitly, what you don't give up, you keep, but also explicitly said in the 10th Amendment is that whatever powers are not granted to the federal government in the Constitution remain with the states or the people. That was Madison's view. He says, look, Congress has its list of powers, the rest remains with the states. You can't override the states for this purpose unless they give their assent to it. Now, Madison, again, to emphasize, he does agree with this bill in principle. Because I'm not unaware of the great importance, roads, of canals, improved navigation, and water courses. He says, look, I'm not saying that the subject matter and the content of this bill is unimportant, or that these actions in theory shouldn't be pursued at all. But he's saying for Congress to raise the money to pay for these improvements and to make this happen, he says he believes that to be unconstitutional because that is not a specific power given to Congress by the text of the Constitution. And so he vetoes it. He says, but seeing such a power, he says, he even says it'll signal advantage to general prosperity. He says, look, I think this is a good idea. Maybe he wished it was in the Constitution. He says, but seeing that such a power is not expressly given in the Constitution, and basically that you can't get there by interpreting it. He says, and also believing that the permanent success of the Constitution depends on the definite partition of powers between the general and state governments, he concludes, I have to veto the bill. So his 2 points there. I mean, he actually makes more than two, but he says, look, number one, it's not in the Constitution. And number two, he also believes the importance between of a distinction, a partition of powers, a division of powers known as federalism, the spreading out of political power through other governments, a more polycentric system instead of monocentric, unicentric. Okay, so it's a spreading out of power. That's what federalism really is at its core. So he says, number one, it's unconstitutional in his opinion. So he vetoes it on that basis. But he says also, for Congress to do this, this would be taking away that power from the states, and the states did not grant those powers in the Constitution. Therefore, it would be federal government overreach against the sovereignty of the states. Now, we may disagree with Madison here. We may say he was wrong or all this, but it is something to think about, the fact that at least one point, probably several, but at least at one point in American history that we can identify, that a president took his oath of office to uphold the Constitution so seriously that he was willing and actually vetoed a bill that would have done something that he thought was a good idea in order to fulfill what he believed to be his role as an interpreter of the Constitution. And you're not seeing this today. This is not the view of most presidents. That being said, what is the true role of the president? If not this, then what? Presidents really be the ones to run the country. Is an individual, given the vast amount of powers a modern president is today, is anyone really sufficient for what the expectation is? Can any individual really run a country? Can any individual really, ought they to really possess that amount of power in a modern presidency? Or should it be a little bit closer to how James Madison viewed the role?